Good afternoon, everyone. Thank you so much for joining us today. For those of you who don't know me, my name is Katie Schaefer. I am the legislative representative for CNY SHRM, but I'm also a labor and employment law attorney at Schoeneck King here in Syracuse, which is kind of a long-winded way of saying I help employers with lots of problems they have with their employees, including harassment training, investigation, and complaints in defense of those complaints. One of our goals at CNY SHRM is to try to get you members more legal content, to put that in front of you. And I know it can be difficult to attend in person some of our monthly sessions, so we're trying to do this by webinar to see if this is helpful to get you some timely updates here. So let me know your feedback on this. I think this is a really important, really timely topic for everybody. There have been multiple new laws in New York State on this topic that really drastically changed the landscape. So it's important for every single employer to be aware of them, to be on top of them, and to know what they need to do to comply with them. I am able to see questions here. Sometimes it makes more sense to go through the whole presentation and to answer them at the end. And I try to pick out ones that are generally applicable. So don't be upset if I don't get to your question, but I do think there'll be some time at the end. So if you have them, please feel free to submit them. Okay, so without further ado, let's jump right in. And before we start talking about the most recent laws, I think we have to go back to where this all started a few years ago, something we like to call the Weinstein effect. Has to do with this charming gentleman here. I use that term very loosely, and the fallout from that, it really caused a cultural change, not just from Hollywood, with so many well-known actors, politicians being named in these kinds of complaints, really has trickled down to everyday life, including in the employment practice as well. And what we're seeing now is a lot of these laws, especially in New York State, are in response to that. Kind of this outrage that this is still a problem after all these years, that it's still an issue, and that so many people feel unable to come forth and complain. So that's really the impetus behind all these laws, is to trying to make that landscape different for harassment victims. So if you remember, at the end of last year, there were a number of new laws that came out regarding things like policies and trainings and prohibitions on confidentiality agreements. I'm going to refer to those for ease of reference as the 2018 amendments. And I want to go through them a bit to make sure everyone's up to speed, but these were all really focused on sexual harassment complaints and issues specifically. There's been another set of new laws just passed this summer that really focus on all types of harassment. So I want to make sure we clarify those and make sure you're all up to date. So let's go back to 2018 and make sure we're all on the same page here. So I do see that there's a question asked about getting the presentation slides. We can make those available. And I think we'll get the handouts to everyone afterwards. So let's jump into the 2018 laws here. So one of the biggest requirements was specific requirements for a sexual harassment policy and things that had to be in that harassment policy. So all employers were required to adopt and distribute a written harassment prevention policy. And before, this was kind of a best practice. It was a way to assert a defense to these types of claims, and we'd always recommend it, but now it was the law. Everyone has to have that. It has to meet or exceed the minimal standards set by New York State. There was a model policy that was put forth in October of 2018. They did it a whole 8 days ahead of when you had to implement the policy. So that was very helpful and easy for employers to comply with. So we kind of, rushed to review that, and we put out lots of trainings on that in the meantime. But what I want to remind people of is that that policy is sufficient if you want to meet the standards in New York State. It's their model policy. However, I think there are a number of issues with that policy. There's things that are unclear. There's things that go beyond what's required by law. So just one example I want to give is that the model policy talks about every single harassment complaint that you get. You're going to follow a very long list of steps. You're going to collect all the documents. You're going to do a written report. You're going to document it for every single complaint you get. And I think for most people that sounds reasonable, but if you work in this area in practice, that's not always the case with every single complaint. And the problem is, if you adopt a policy that you don't comply with, say it's a minor complaint, and the person says, "Oh gosh, I said that, I didn't mean it," and you can just deal with it that way. way. And you don't end up writing a huge report for it and making a new file for it and all of that. If you don't comply with your own policy, then that can be looked on as if you're not responding appropriately to that complaint. So I do think you want to take a hard look at what your policy says, make sure you're aware of what it says, make sure it meets those minimum standards, and then make sure you're following it. It's really important that you're actually following your own policy, because that is pretty good evidence that a complainant can bring forth and say they're not even following their own policy. So just a reminder, you had to have that policy in place by October of last year. If you don't have one in place that meets all these minimum standards, it is very important that you get on that right away. One of the first things that they're going to be asking for any kinds of investigations is a copy of your harassment policy. So do make sure that you're up to date on that it's available, and that is in place. So some of the things that they said your sexual harassment policy had to include were things, a prohibition on sexual harassment, consistent with guidance by the DOL and the Human Rights Division. Examples of things that constitute unlawful sexual harassment: information about the statutes and provisions concerning sexual harassment, the remedies available to victims, and a statement about local laws. So this was something that a lot of policies before didn't have. Statements about the availability of the EEOC, the division, where you can go to file those complaints, remedies of redress even outside of your organization. Most policies didn't include that. Now they're saying that the law says you have to include those things. You also have to have a procedure for timely and confidential investigations that ensures due process for all parties. I think that term is a bit of a loaded concept, due process. It has different meanings in the law, very specific meanings in the law in different contexts. So one way around that, one way that we've talked about is explaining in our policy that Bond has put out what remedies we're going to give to everyone accused of a harassment complaint. We're going to speak to everyone, provide them notice, provide them the opportunity to give us witness names, to provide documentary evidence, and that way we're going to comply with due process in that way. So we're going to clarify what we mean by that. The model policy just says due process, and in my view, that's a bit unclear as to what that implicates. Some other things the policy has to include: information regarding rights of redress in the available forums. So again, you've got to specifically mention the EEOC, how to contact the EEOC, the same thing with the State Division of Human Rights and how to contact them. You have to include a complaint form. This is something new that a lot of policies before didn't have as well. The complaint form doesn't actually have to be attached to the policy, but you should reference it. If you don't, you should reference it and make it very easily available. So for example, you have an intranet or a website that your employees can go to, make sure it's readily available there. Important to note, employees don't have to use that complaint form. So if someone comes to you and makes a verbal complaint of harassment, we can't say, well, put it in a complaint form. If they don't do so, then we're done and we don't have to go further on it. We have to investigate that complaint even though it was only made verbally. So the complaint form is voluntary, but you do have to have it. So it's voluntary for employees to use, but we must have one. So there are a couple other things that the policy has to include. The sexual harassment policy has to include that it constitutes misconduct and that sanctions will be imposed for this, especially for supervisors and managers who knowingly allow such behavior to continue. A statement about unlawful retaliation for those who complain of sexual harassment or testify or assist in any investigation or proceeding involving sexual harassment. You got to make sure that's listed in there. That's very clear that that's independent grounds for discipline. Another big piece of the 2018 laws was that employers were required to provide annual harassment prevention training. Just a reminder here, because we get this question a lot, that training time is required. Employees have to be there, so it's generally compensable time. So make sure you're compensating your employees for attending that training. New York State has said that all employees must receive that training prior to October 9th, 2019. So we're quickly approaching on that date. If you don't have plans to get your employees trained, please do so right away. It's important that you get that in by October 9th and that you do it annually and every year after that. And what basis you do for that annual calculation is up to you. You can do it on a calendar year. You can do it on employees' anniversary dates if you want to stagger different employees. You can do it on a date you select if it's convenient for the employer. But you do have to make sure that you do it before October 9th for everyone, and they do it annually after that. You should also be training your new employees as soon as possible. Previous guidance from the state had said that had to be done within 30 days. They backed off of specifically stating that. However, I think that's a good guideline to keep in mind, is that it should really be done within that time frame. Okay, so what does your training have to look like? So remember, it's got to be interactive. It's got to be something that includes some interaction with your employees. It can't just be, you know, a video that they plug and play through, or reading a document. That's not going to be sufficient. There are a number of ways you can do this. You can do a web-based. If you have questions they have to select, they answer the correct questions. You could do a live in-person training or something by video where they have the opportunity to ask questions or receive feedback by that. You could have them complete a feedback survey at the end of the training. I have found that live in-person trainings, whether that be internal or from someone externally, are probably the best practice here. It's not always you're not always able to do that. My advice is to try to intermingle that as much as possible. So every few years, do a live training. I think it just indicates a level of seriousness and commitment from your organization that employees tend to take that more seriously than a video they have to go through and answer questions about on their own time. For whatever reason, they tend to kind of do that and perhaps ignore that. But if you can intermix that live training every now and then, I think it does send that message. And the EEOC actually did a study about the importance of having that top-down commitment from employers and how much employees take that to heart and how much they comply with that. And then they take that cue as to how serious the employer takes it as how serious they must take it as well. So that's my plug there for your training. I know a lot of versions are out there. There's insurance companies, for example, offer some versions of this training. Just make sure you review it, make sure it meets the minimum requirements. I reviewed quite a number of samples myself that are not New York compliant, that do not meet the minimum standards. So be careful of using kind of canned or free presentations that you might find out there, and make sure that it's compliant before you use it for your employees. So the minimum standards for the training says it has to include an explanation of sexual harassment consistent with guidance by the DOL and DHR, examples of prohibited conduct, information about federal, state statutory provisions concerning remedies available, rights of redress, available forums for adjudicating complaints, information addressing supervisor conduct and responsibilities. So here are just some best practices I think it's important to remind you of. I think it's well worth it if you're able to do it, to train supervisors and non-supervisors separately. It just allows for more discussion from both groups of employees. You can have a more tailored discussion for your supervisors as to their obligations. For those in a supervisory capacity, you may be able to exert attorney-client privilege over that meeting so that he can feel free to come forward and say, if an attorney is doing that training, to say, well, I've had this issue. What do you think of this? And the conversations that you have, and sometimes you're a little dismayed, you're a little confused and shocked by what supervisors can bring up. But if you do have it in a separate session, at least it's not being uttered in front of your employees, your rank and file employees, and you can remain privileged over those conversations. So if you can do it, I think it's a good idea to train those two groups of employees separately. So live training, again, it's always the best in my mind. It's not always practicable, especially if you're talking about getting new employees trained on a regular basis, but to the extent you can mix that in, I think that makes a lot of sense. Talk about your own organization's harassment policies and procedures into the training material. So when you're training folks, you should be referencing the policy, whether that's after the program, if you do some kind of video or web-based program, tell them who they can report to. I think that's important that they know these are the individuals. It's the director of HR and a supervisor, for example, and list them out so there's no question about that they know exactly who they can report to, for example. Try to keep it engaging and fresh. Don't do the same thing year after year. That just tends to employees to ignore that kind of content. And the law is always changing as well, so make sure you're keeping up to date on that. Use examples that are appropriate for your workplace. If you work in a manufacturing setting, you shouldn't be using, office examples, and vice versa. There's some things that are just more appropriate that you see more often in your workplace. Use examples that are consistent with the issues you've seen, so that everyone can benefit from that in a non-identifying type of way. But the types of issues that you've seen or you've dealt with, take those and use them as hypotheticals or examples in your training. And set the bar, and I think sometimes we get, whenever I've done these trainings, you can tend to get some pushback from employees who say, well, we're just being so sensitive these days, and you can't even say anything to anybody anymore, and it's always, it's harassment, you can't even say hi to anybody anymore. We have to tell them that, look, whether or not you agree with the law and what the standard is, this is the standard now. There's no question about it. There's no leeway about it. And the bar for our employees is to be respectful 100% of the time, to be professional 100% of the time. And if you're doing that, if you're being professional and appropriate, you're not going to have a problem, right? So there was also a provision about non-disclosure provisions that you could not include them. You can't require them to resolve sexual harassment complaints. It had to be the complainant's preference to do so, and to document that that was their preference, there was a complicated 3-step process for doing so, including they had to give them a full 21 days to consider the agreement. They had to have a written agreement documenting that preference, as well as 7 days to revoke that agreement. So what this looked like in practice is that if you're solving a sexual harassment complaint, it said essentially you have to have 2 separate documents now, the actual settlement, and then one documenting that it was the complainant's preference. The 2018 laws also really expanded the law to apply to non-employees as well. So you can be liable to a non-employee for sexual harassment where the non-employee is a contractor, a subcontractor, a consultant, or another person providing services pursuant to a contract, or an employee of someone under the foregoing. The employer knew or should have known about the harassment, and the employer failed to take immediate and appropriate corrective action. So what this means in practice is that we have to make sure that our employees are not harassing folks that come onto our work site to perform work. So for example, the copier machine repairman may come on site to perform work pursuant to a contract that we have with that company. Our employees cannot harass that person, and vice versa. If that person is harassing our employees, that's something we have to make sure we're taking care of as well. So that was the 2018 laws, but because we're in New York State, we have a whole host of new laws to think about now, and we want to touch on. So these are some of the highlights of the 2019 New York amendments. So first of all, it's a much easier burden now to claim unlawful harassment. There's a brand new legal standard that's put in place, and really the effect is that it lessens the proof required to make a claim of harassment. And I think that that provision is actually a game changer, way more than the policy and the training aspects, because none of that actually changed any of the underlying law. What this 2019 law does, it changes the whole standard for what actually is considered harassment in the first place. And it really does change the whole atmosphere here. So it's really important that you're aware of that your employees are aware of that. All the more important that we're really stressing these trainings and these preventative techniques so that we try to avoid these claims, because it's going to be much harder to defend them. There are limitations on employer defenses now, talking about employee complaints and whether or not that happened or whether or not that's a defense. We'll talk about that. Expanded protection for non-employees and broader penalties and remedies. So something to note here is that the 2018 laws all really focused on sexual harassment, whereas these new laws in 2019 really focus on all discrimination and harassment complaints generally, not just sexual harassment. They also broaden the prohibition on confidentiality agreements. They expand prohibition on arbitration agreements, and there's new training and policy related requirements for sexual harassment as well. So we're going to go through all of these and talk about all of them, but that's kind of the landscape of what we're looking at here for 2019. So one of the biggest changes here that kind of quietly snuck through, there was a lot of fanfare about the 2018 law and the policies and the training that were required, and we heard about that a lot beforehand. But this new law kind of flew under the radar a bit, but I think it's really, really important. And I think it's more of a game changer than the 2018 law. So the old standard, as many of you may be aware, was that conduct had to be severe or pervasive under both New York and federal law. So that's still the federal standard, but the New York standard has done away with that. And for those of you who may not be familiar with that standard, there was a whole bunch of case law on that topic, but essentially what it meant is that a one-time incident probably wasn't going to meet that standard. Unless it was something very severe like a forcible touching, for example, then it might meet the standard. But in most cases, it had to be a pretty good pattern of conduct that built up over time to eventually get over that hurdle for what was considered pervasive. But most of the time, you know, one or two stray comments, probably wouldn't meet that standard. So what this law does, it completely does away with that severe or pervasive standard under state law. So now the standard is obviously very much lower. It's simply that conduct subjects an individual to inferior terms, conditions, or privileges of employment. So that is a much, much lower burden to bear. And like I said, it's a real game changer for what's going to be actionable conduct, what we have to respond to in the workplace. When we're defending claims, it's a big game changer. In addition, they've said that no comparator evidence is required. You'd have to show that others are treated differently. They've specified that the interpretation under federal law is not controlling because this is very different now. And they've also specified that the exceptions to liability are going to be construed narrowly and that the remedies for liability are going to be construed broadly. So what that means to me is that in close cases, they're going to go in favor of the employee. All of these changes are effective as of October 11, 2019. There's also limitations on employer defenses under the human rights law. The old standard was a failure to complain that was a legal defense. So what this looked like a lot of the time is that we'd get a complaint. An employee says, well, I've been subjected to all these harassing conduct throughout my time here, all these different comments that were made. And oftentimes that was the first time an employer had ever heard of these things. The person never came forward to complain to the employer before that time. That would give us a legal defense because we said, look, the person never complained, they never put us on notice of this, so we can't be found liable for it. We can't remedy things that we don't know about. The new law says that even though an employee does not complain, that claim is still viable. So it does away with that defense that's saying if an employee doesn't complain internally, we have a defense there. And that's a tough thing to deal with because now we have a case where we may have the very first notice we have of a complaint is when we get it from the Division of Human Rights. That makes it really difficult to defend. So there's a question, mostly among legal circles, as to whether or not we still have some sort of a defense in those areas, because there is a concept, condemnation concept under New York law, which says an employer is not liable for an employee's discriminatory act unless it became a party by encouraging, condoning, or approving it. And if you don't have that, then we can't be liable for it. Now, some would say that we still have that standard available. We still have that respondeat superior defense available, even though the new law says if they don't complain, the claim can still be viable. Others would say this new law saying if you don't complain, the complaint's still viable. That means what it says. It was intended to do something, and you can't rely on this respondeat superior concept because the new law does away with that. So I think this is something that's going to have to play out in legal challenges and maybe before the courts to see where they'll fall on this. Myself, I take the view that we can't bank on that being the case. I don't know that we can bank on that. Well, we didn't know about it, we didn't condone it, so that we can't be held liable for it, because I think the legislators would say, and I think certainly the Division of Human Rights would say, we intended this new law for a purpose, we did it for a purpose, and that was to change the current standard. So we're going to do away with this defense. So you may have cases where, especially in front of the Division of Human Rights, they say, just because you didn't hear about it until we get a complaint, that's no defense, and you're still going to have to, you could still potentially be liable for that. So I think it remains to be seen what will happen with that. There's potential that might still be out there, but don't bank on it. Of some small comfort, perhaps, there is a limited affirmative defense that the new law puts in place. It says anything that is not actionable if it's a petty slight or a trivial inconvenience. And I think it's also worth noting that they put that in the perspective of a complainant in the same protective category that's coming forward. So someone, a reasonable person, and that complainant, same protected category, would they consider this action to be a petty slight or trivial inconvenience, which I think is different from your general standard reasonable person in the reasonable population. And what this means, we don't have a lot of guidance on it yet. What I can tell you is that a petty slight or a trivial inconvenience is a much, much, much lower bar than severe and pervasive. It's much lower than what it used to be. So at the end of the day, we know that it's going to be a lot more conduct is going to be actionable. And all the more reason that we have to impress upon our employees the seriousness of this. They need to pay attention to this. We have to tell them that we can't tolerate these types of things in the workplace, because it may be the fact that a few comments here or there may actually meet that standard now. And those changes are effective October 11th, 2019. So we do have a little bit of potential guidance here, because the law in New York City actually uses a comparable standard as this kind of petty slight or trivial inconvenience standard. So we may be able to pull from some of those cases to try to get an idea of what that standard falls. But in looking at those cases, it is not a very clear standard. It's a very gray area, and I think you could argue that some of the same conduct has been found actionable and some has been found unactionable. So just take these couple examples. These are examples pulled from actual cases. So the first one is a crude anecdote about someone's sex life that they shared in the workplace, and the occasional reference to an employee as voluptuous. That one was actually found lawful, so it was not actionable conduct under the New York City law. The next one is the employee said that all women are, excuse my language, bitches except for my mother. So he sounds like a really wonderful person. That was actually found to be lawful too. That actually was not found to be above a petty slight or trivial inconvenience. The third one, complimenting a female employee in her hair and her boots and lightly squeezing her thigh for a second while they were seated together. I was found to be actionable. And so taking just those three examples, I'm not sure you can draw a real clear line between what's actionable and what's not actionable. So again, I think the moral of the story is that the bar is much lower now, and we have to kind of keep the line of keeping a respectful professional environment 100% of the time. The new law also expands protections for non-employees. Covered non-employees in the workplace are protected against any and all forms of discrimination and harassment, so not just sexual harassment. So this is a similar concept from what we saw in 2018 aimed at sexual harassment, except it's expanded to all different types now, not just sexual harassment. So all different types of harassment under any protected category covered of non-employees now. The test again is did the employer know or should have known about it. That the non-employee was subjected to discriminatory practice and failed to take immediate and appropriate corrective action. So again, really important that we are including not only in our policies, but our actions. If we know about it, if we have reason to suspect it, if our supervisors know about it, or we get a complaint about it, that we're taking immediate action, even if that person's not our employee. So the response may look different, right? We can't necessarily fire non-employees because we don't have that control, we don't have that authority, but what we can do is take action to make sure that the harassment doesn't continue and that we prevent it in the future. So it may look like contacting the person, the entity we contract with, and say, don't send this person to our workplace anymore if they're harassing people. Or it may be that we institute discipline against our employees if they are harassing a non-employee. And just because someone is a non-employee, if they're working in our workplace, we have an obligation to make sure that they are protected from harassment. Those changes are effective in February 2020, by the way. There's also changes to the non-disclosure or confidentiality of claims, a broadened ban on confidentiality clauses and agreements addressing any and all discrimination claims. So again, not just sexual harassment, it's broadening it up to all different types of discrimination and harassment claims. Again, it can only be used if it's the complainant's preference and it follows the specific legal process, which is very similar to what we heard about for sexual harassment complaints. So again, I think the big difference is the full 21 days waiting period, which some of you may know is similar to the Older Workers Benefit Protection Act for settlement of federal age claims. We have to give them a full 21 days to consider the agreement. The difference there is that under the Older Workers Benefit Protection Act, they can waive that. They can say, fine, I want to sign on day one. Under these laws, they have to have the full 21 days, regardless of whether or not they're amenable to signing on day one. They have to have that full 21 days and they can't waive. The terms must also be written in plain English and, if applicable, the primary language of the complainant. The confidentiality provision cannot limit subpoena-related activity. It can't limit cooperating or participating with investigative agencies, providing information related to unemployment insurance, Medicaid, or other public benefit claims, or disclosing factual information related to future claims, unless also advising that the party can speak with law enforcement, EEOC, the Division of Human Rights, and other entities. That law is effective January 2020. These other changes are effective October 2019. So that one small piece, that last piece, is effective 2020. Everything else is effective October 2019. Mandatory arbitration clauses. So there is a broadened ban on mandatory arbitration clauses and agreements addressing any and all discrimination claims. So before, I didn't mention this before because of this court case I'm going to talk about in a second here. There was a ban on mandatory arbitration clauses with respect to sexual harassment complaints. However, there was a court case, Latif v. Morgan Stanley in the Southern District in 2019, just this past June, which said that prohibition is unlawful. It violates the Federal Arbitration Act, and so it's unlawful. So it did away with it. Now, presumably, this new law was already in effect and it passed, at least through the legislator by this time. So it has gone into effect with respect to all types of claims. However, that court case had a footnote which said presumably the same result would happen with respect to this law. So I think we can take the position that it probably would be found unlawful as well under the Federal Arbitration Act, and we would be able to enter into these arbitration agreements. It may just take another legal challenge for that to be clarified, but that the court did recognize that this law was out here and pending, and that it would probably be subject to the same provisions. But the law itself does become effective October 2019, so we need to wait for a case to clarify that for us, but it's probably likely that it will also be found unlawful under the Federal Arbitration Act, meaning that you can enter into arbitration agreements with your employees. But there's also additional changes for mandatory sexual harassment and training policies. The policy must be provided at a time of hiring and at every annual training program. So this is a bit different from before. There wasn't a specific requirement before. So now when you're orienting people, when you're onboarding them, make sure you're providing them a copy of the policy. When you're doing your annual trainings, make sure you're providing them a copy of the policy at that time as well. Also new is that the policy and the information presented at the sexual harassment training must be provided in English and in other primary language of the employees. So those changes are effective immediately. So if you're doing your annual trainings, as you're going about doing them, make sure you're providing them a copy of the policy at those. Some other significant new changes. So employers of all sizes are covered under the human rights law. So it's really expanding the scope of that. As you may know, under federal law, there are some exceptions for smaller employees. If you're under 15 employees, for example, you may not be subject to those laws. New York State has gone the other way with it and said, under New York State law, you're going to be subject to our laws regardless of the number of employees that you have. There was a movement to kind of change that with respect to sexual harassment, and now it's expanded to all different types of claims. So employers of all sizes, no matter how few employees you have, you are going to be covered under the human rights law. The new law also mandates the award of attorney's fees to a successful party. So really, that means a successful claimant. Unless you are a successful defendant, in which case you have to show the claim was frivolous. So you're only getting attorney's fees if you can show the claim was frivolous, if you're a successful defendant. If you're a successful complainant, you are mandated attorney's fees for that claim. So what those two things really indicate to me is that you are going to see private attorneys at every single Division of Human Rights complaint now, in every single fact-finding conference that you have investigation before the Division of Human Rights, because there's a huge incentive now. They can be awarded their attorney's fees just for having a successful complaint. They don't have to wait until they get an award and get a piece of that award. They can claim their attorney's fees from this law. So you're going to see a lot more complainants that are represented. So they're being told now in our policies and in our training how to file a complaint with the EEOC and the Division of Human Rights, if that's available. They're being told now that and plaintiffs' attorneys know that they can collect these attorneys' fees if they're successful on these complaints. So you're going to see a lot more parties represented, a lot less pro se before the Division of Human Rights, for example. We've also changed the statute of limitations. Instead of being 1 year to file with the Division of Human Rights, it's now 3 years. So they're expanding the scope of what they can complain about. You're having a much longer period of time that you can make a complaint for the Division of Human Rights. It used to be that it was 3 years if you went to a court, you had 3 years to complain. If you filed a complaint directly in court, although most people didn't want to do that because it's much more expensive. You have to have an attorney to do so. There was a lot of hurdles to get over filing a complaint in court, whereas filing a complaint with the Division of Human Rights was pretty easy and pretty inexpensive for complainants. So much more preferable there for complainants. So now they're making those equivalent now. It's 3 years if you're filing in court, or 3 years if you're filing with the Division of Human Rights. Punitive damages cannot be awarded against the state or local departments or agencies or local commissions, but they still do apply to private employers. So the availability of punitive damages is there as well. So again, what you're going to see is a lot more of these complaints. We've already seen a huge uptick already in harassment complaints. So you're going to see that, and you're going to see people lining up with attorneys as well. So practical recommendations based on all this. You want to make sure you're revising your mandatory sexual harassment training program in your policy as needed. Make sure you're in compliance with the law now. If you had specific references to statute of limitations, to the standards, to a severe and pervasive standard, make sure that's not in there anymore. Make sure you're aware of the new standard and that your folks are complying with that. Obtain translations of your sexual harassment training and policies materials as necessary. So if you have people whose primary language is other than English, make sure you're getting those translated appropriately. Review your existing personnel agreements to address confidentiality and arbitration issues, including employment, severance, and non-compete agreements. You want to make sure you're in compliance with these new laws with all those respect to those areas. So you can't just chug out and plug in the same things you've been using in the past. You're going to need some revisions there. You're filling those types of claims. You're trying to do those types of non-compete agreements. Make sure that they're up to date with technical review. You want to really educate your leadership about the significant changes, especially the new lower threshold for harassment complaints. And I think I've mentioned this before, but I'll mention again because I think it's really important that your employees see that top-down commitment from the brass in your employment. That it's really important that they understand that their employment place takes this seriously, that this is not going to be something that's tolerated, and that they get on board with that. And so it's important that your managers, your board, your presidents, your CEOs, that they're all aware of these changes and the implications for them, and that everyone's on board with the fact that this is the law now, and that there's little tolerance for these types of things. And I think you need to stress in your trainings that this is one of those areas that may subject employees to immediate dismissal. First time you're aware of that employee harassing somebody else, that could be subject them to immediate dismissal. And whether or not they agree with the law or not, whether or not they think that's a good law to have, whether they think we're all too sensitive and we're not able to talk to each other anymore, and they think this is a tragedy, it doesn't really matter at this point, because the fact of the matter is it's the law and there's liability attached to it. So we all need to get on board with understanding that things that are able to happen in someone's private life, with their family, with their friends, outside of work, are very different from the standard that's acceptable in the workplace. And I think that's the way you describe it to them, is that it's not the case that you have the same kind of conduct that's okay outside of work and inside of work. We have a very different standard of conduct that's acceptable, and you need to keep it professional and appropriate at all times. Create or review your investigatory procedures and plans. So you really have to make sure that you're promptly addressing complaints. Gone are the days where we could kind of wait a couple weeks and see what happens with it. Employees are aware that you have to investigate promptly. It's written in our policies now. Everyone expects it, including the division, including the EEOC. They expect to see an immediate complaint and an immediate response. It doesn't mean we have to rush through it. I still think we need to do it appropriately. But think about these things beforehand. Think about who's going to be investigating these types of complaints. Do you have someone who's capable to do that on staff? Or do you know who you're contacting if that's not the case? Who's going to be involved? Who's going to be decision makers? What steps are you going to take, and how quickly can you get it done? Think about it beforehand so you're not caught flat-footed when you get a complaint. And use your training to raise your emotional IQ of your workplace. You know, enhance empathy of your staff and especially your supervisors. It's really, really important that you drill this message into your supervisors. And the way I've done it in trainings before is to say that, look, we all come from different walks of life. We all have different backgrounds, different histories. And what some people are comfortable with, other people aren't. What some people find funny, other people don't. We don't get to use our own level of sensitivity and expect everyone around us to have that same level of sensitivity. We have to put ourselves in other people's shoes and understand that other people might not be comfortable with the same kind of conduct we are. Things like hugging and kissing in the workplace or physical touch, or jokes that you may find funny, other people might not find funny. And it's simply not an excuse anymore to say, I was trying to lighten the mood. I didn't intend to be harassing about it, because that is not a defense. The law says that you can have the purpose or effect of creating a hostile work environment, meaning that the person may not intend to be harassing. They may intend to be funny. They may intend to tell a joke, but it has the effect of harassing. If it meets that legal definition, that's all it's required. So the person's intent is not important. It's what's the impact is on other people. And I think that's a good lesson for all of us to keep in mind as we kind of go through life anyways, just to think about other people and what they may be sensitive to, what might upset other people, and act accordingly, at least in the workplace. You want to make sure you're carefully documenting all employee complaints. So remember that your standards now are just something that's above trivial or petty, much lower standards. So gone are the days where you're going to say, well, that was just a one-time comment and we're going to kind of overlook that. It was a misunderstanding. We're not going to cause any drama and look into that any further. We really need to document all complaints, and we need to investigate all complaints, no matter how trivial they may be, because our standard is really pretty low now. We want to show that we looked into it promptly. We want to show that we investigated it and we came to the right conclusion. So it doesn't mean that every single complaint results in automatic termination of the person. We're still going to follow all our processes for due process and give everyone a chance to tell us their side of the story, to give us their evidence, to identify their witnesses. But we have to make sure that we're responding in a way that's going to deter that from occurring in the future, to make sure we get the message across of what's acceptable and not acceptable conduct in the workplace. And so what that looked like depends on the facts of the case still. It might be that a written warning is sufficient, and we lay out those expectations again from there. It might be that it's of a nature that's so severe enough that we say, we're going to terminate this employee at the first time. But again, we want to make sure we're documenting, make sure you're complying with your own policies, what your policy says you're going to do. And if you've adopted that state model policy, keep in mind it says you're going to make a written report and collect a number of documents for every single complaint that comes across your desk. And keep just spreading the word that we need to be respectful, be professional 100% of the time. It's not the case that we're going to let people get away with inappropriate comments. We're going to make sure that we're all being respectful and professional 100% of the time. Just a plug here, because we have seen a number of presentations and programs that have been that I've seen online that just aren't sufficient. Bond has come up with a compliant New York State and actually for New York City as well, web-based interactive training program. So this is our material, so we know that it meets all the minimum standards. We know that it meets all the minimum standards for this law as well. And this is something that it's pretty reasonably priced. It's by the person. I put this here because I want to make sure that people are getting training that meets the minimum standards, and it's not always possible to have a live person do it. You may not have that person that's capable on staff or be able to bring in someone to do that live training. This is a nice alternative for those when you have new employees coming into the workplace, or you can't get, you want to do makeups, for example, or you just can't get a live person in the workplace. It's a good way to make sure you have compliant training and good training given to your employees. So if you need any information about that, let me know. But like I said, just make sure if you're getting some kind of web-based program or canned program from someone else, make sure that it meets those minimum requirements, because that's really important. It's an independent violation of the law if it doesn't. Okay, so we have reached the end of our presentation. I don't know that we have any open questions. So if you think of anything after the presentation, please feel free to contact me. My email address will be in the materials that we send out.